Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for
Hello, everybody. Thank you so much. If you were just here watching our premiere, oh, that rhymes, my dear. Thank you. Why is my lipstick like that? I all fucked up. That was a video that already premiered. We're gonna watch some other stuff today. So buckle up, Buttercup, and we'll see what we've got. I just want to say it was so obvious. The girl was showing off her ring on that live stream. Hey, she was just like, oh my God, what, this? No. Oh, Michelle, we missed you. We're sending you good vibes. Nice to see you. Yes, my bedroom still, by the way. Anyways, but we have quite a lot to watch tonight, so let's get going, shall we? Uh, we'll start with Ronlick. No, Kirkham. You look so happy.
Yes, making nice with Stu work. It's here, just to know good.
You're muted.
No, I'm not.
Okay.
No, neither of you are muted, but you both should be.
You look good today.
Oh, fuck, he did not just say that. Oh my God. Oh. 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 I hate how I respond to that naturally too. I'm like, damn, don't I? Why is it that we women, why? Why? Girl, she was like, she's gonna smile the second I hit play. She's gonna be smiling though, MB. She's like, no, don't say that. Probably because this is a child support hearing. I don't even know what's gonna happen. Oh my God. Oh, fuck. Hold on. I'm gonna go back like 10 seconds. Watch her face, listen to him. You'll see.
No, I'm not.
Okay.
You look good today.
Are we in the waiting room?
The 37th Circuit Court is now in session with the Honorable Brian Kirkham presiding, calling case 2023-3395 Dana Allen versus Michael Noble. Today is Monday, June 10, 2024 at 10:33 a.m.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the plaintiff's motion for entry of order determining any child born out of wedlock. Ms. Allen, in this case, before we can do that, we're going to need an evidentiary hearing, and I do note that we do have in the file an order for genetic testing. I assume, Ms. Allen, that hasn't been done yet?
No, it hasn't been done. But the biological father has moved to Georgia. But he also has two child support cases out of Kalamazoo County. and I am acquaintances with one of the other mothers, and she did say if worse comes to worse and it's an option for me, that she would consent to like a sibling DNA test if that's even possible. But he is out of state in Dalton, Georgia now.
Okay. And what's the name of that individual, Miss Allen?
The father,
Yes.
Dakota Torres.
Well, the court will order the genetic testing of, again, Miss Allen, you, the child, and Mr. Noble. We can at least, if he's to be excluded, we can exclude him. And then you'll have to follow up with Mr. Magnuson on Mr. Torres.
Okay.
So,
Um,
Magnuson, I think you put in an order for genetic testing, or was that you, Miss Allen?
I put the order in.
Okay. Okay,
That's correct. That's correct, Your Honor.
okay. Miss Allen, why don't you do that? You can call Mr. Magnuson at the front of the court's office after this hearing and coordinate when you can get in to do the genetic testing, and then let Mr. Noble know as well, and then he can get in and do the sample, and we can get that, at least get that part resolved.
Okay. That will be fine. I can honestly, is it appropriate for the testing if Michael was incarcerated and I can prove that? Or do you still want it done anyway?
Oh, so, well, Mr. Magnuson, I guess it would depend on the time of conception based upon the age of the child. If, let's say, for instance, he was incarcerated until, 2 months before the child was born, obviously he couldn't be, the biological. So we wouldn't need to do the testing if in fact the facts would bear that out. I just, based on what's been filed, I don't know what those facts are yet.
So, I guess I filed it wrong. I was gonna ask for the genetic testing to be in order for Dakota and not Michael, because Michael was incarcerated March 22nd of 22. I got pregnant in June of 22, and my daughter's 1 year old, and Michael just got released from prison in April of this year.
Okay, well, Mr. Magnuson, do you acknowledge that there's probably no need to have Mr. Noble attested?
It sounds like it, Your Honor, based on what is being represented.
Okay,
I'm just kind of looking forward. If those are the proofs that come out at the hearing, I'm guessing that
okay,
clear and convincing evidence standard would be met.
yeah. What we'll do, Miss Allen, I'll have you after court, you can call my office and we'll set you up. We do those hearings on Wednesday afternoon at 1:30, and we're gonna need more time when we can take some testimony, because I have a number of hearings today and I can't take testimony today.
Okay.
So, if you'll call and and then if you can relate that to Mr. Noble, we'll have him come in and he can testify as well to those facts. And then we wouldn't need to have testing of him done, but I'm sure Mr. Magnuson will require that there be some testing of Mr. Torres.
Yeah.
And, as you proceed.
Absolutely.
Okay, but Mr. Torres at this point is not added to this case, so you'll have to file a separate action against Mr. Torres.
Okay. Yep. No problem. The prosecutor's office should be able to help me with that. Honestly, I tried to do a separate case the same day I filed this ROPA, and they told me that I didn't need to do that because I was on assistance, and that the FOC and prosecutor would work with me to open a new one for him. So.
Well,
That's correct.
okay,
Okay. Awesome. Thank you so much for your
thank
help.
you. You're free to go.
Yeah.
Have a good day.
You too.
Thank you.
Thank you.
Thank you, Your Honor.
Damn, you thought she looked good, Michael, but she fucking left. She didn't even say bye to you. Also, She got pregnant while you're in jail. Yikes. But I guess they're still married technically. Another weird one. Anyways, Judge, you got a busy day? What do we got? What's going to happen?
Isabella, try and get this one. Please connect audio. John and Isabella,
Hello.
hello.
Oh my God, I thought that was her voice. That was her voice, but it came out of his mouth. Oh my God, my face. Oh my God, that was hilarious. This can't be a couple, right? J Mac, is this a couple? Is this a couple? Is that what's happening here? God damn it. Sorry, Vicky. I hope you won the heist. Lord of the Rings, right? I don't know what this one's gonna be. I don't know what this one's gonna be. Let's see. Oh my gosh, that elf. He looks. Oh, don't say things like that. Basically, just press play.
John,
Hello.
hello. Let me try to connect here. Calling case 2024-939 DC, Isabella Tidwell versus John Nichols. Today is Monday, June 10th, 2024 at 10:40 a.m.
Court will note that both parties are here representing themselves in pro per. This matter is before the court on the defendant's amended motion regarding custody. In this case, court will note that the plaintiff.
Hold on, was that a bait and switch? Where did Santa go? We got John and Isabella down here. Still a bit of a mismatch, but let's see what's happening. Hi, Jody.
Did file a complaint for custody parenting time support. Defendant has filed an answer to that. Mr. Nichols, it sounds the custody will be addressed in the course of that case as we proceed. It sounds like, based on reading of your motion, that you're asking for parenting time at this time. Is that accurate?
Yeah, that's correct.
Okay. And Ms. Tidwell, what's your response to the request for parenting time?
I'm willing to agree with parenting time.
Okay. And how old is the child?
He just turned 1 April 18th.
Well, typically, Ms. Tidwell, just so you know, that the typical standard parenting time is alternating weekends from Friday at 6 to Sunday at 6, then a midweek from 4 to 8. Usually, if the parties can't agree as to the day, it would be a Wednesday. You can agree upon another day if you can, but if you can't, it'll be Wednesday. And then typically, too, is standard for children other than small children is alternating weeks in the summer. What you said you're agreeable to parenting time. What parenting time are you agreeable to?
About every other week.
Alternating weeks?
Yes.
Okay. Okay, Mr. Nichols, I assume that would be agreeable to you.
Absolutely.
Okay. Why don't we do that? We'll and Mr. Nichols, you'll have to do an order for parenting time and put that again, that you would have alternating week parenting time, and that will commence this Friday, June 14th at 6:00 p.m. through the following Friday at 6:00 p.m. and then we alternate each week thereafter.
So I have a question for you.
Yep.
So I would get him this Friday.
Yes.
Awesome.
You get him this Friday, and what we'll do is, we don't need to do that this time, there's a midweek, so each party, so Mr. Nichols, when you have the child, she would be entitled to a Wednesday midweek from 4 to 8 o'clock PM.
Okay.
And then on her weeks, you would be entitled to a midweek. And then you would also be entitled to alternating holidays. And there's
Okay.
standard alternating holidays through the front of the court, and you can look online and get that information. But because you're representing yourself, you'll have to do the order for parenting time. And then you'll have to submit that within 7 days, and then you don't need to have an additional hearing. If you don't get it submitted within 7 days, then you'll have to motion the matter up for entry, and it'll require another hearing. So I don't know if you're using like Michigan Legal Help or something of that nature, but you can go to michiganlegalhelp.org, and they have all those orders and forms and stuff online, and you should be able to just prepare one with alternating weeks, midweek, and alternating holidays.
How about
What? Yeah. So, and you can put in this matter, you can do a calculation of child support as well, based upon the alternating weeks. I don't know if the child is receiving any public assistance, or if mom.
Yes, he is.
What?
Yes, he is.
Okay, then what's gonna happen is we can't deviate from the standard calculation, so Mr. Nichols, you'll have to do a calculation of support based upon what each of your respective incomes are. Court will order that each of you would disclose the income no later than this Friday, the 14th. That way, Mr. Nichols, you can do a calculation, and you can get it in the order, so you can get it submitted before Monday, okay? So you don't have to renotice it up. Okay? And you can do that through Michigan Legal Help as well, do the calculation. Okay. So Ms. Tidwell, you'll have to get him your income information. He'll provide you with his income information. Most current, up-to-date, year-to-date income, and then he can calculate the support and submit an order for the parenting time and an order for child support as well.
Okay.
Okay? Thank you both. You're free to go. Have a good day.
Thank you, you too.
Bond?
All right, where's Santa? Also, I was thinking today, I was learning, I think,
Did our phantom
If they're
person
on-
ever
Yeah.
join?
what, Judge?
I'm having a hard time connecting. I was gonna.
Hmm.
Can you hear me, Motorola?
Yes, Motorola.
Can you hear me?
Motorola.
All right. Okay, so let me try chatting.
Well, get plaintiff on, and that she can identify whether this is the
That's- I'm
defendant.
trying to get her.
Hello,
Go here.
Moto.
Motorola, can you please connect to audio?
Would you respond to Motorola? He probably
Angel?
doesn't even know.
Yes,
Fucking-
Okay, do you know if this is Mark Bond right here?
it is, yes.
Okay, it's having a hard time connecting to audio. Samsung, can you hear me?
Samsung. iPhone.
Samsung, can you hear me, please? All right. Please connect to audio.
They can't
Please
hear you,
unmute.
dumbass.
Please unmute.
I think I got it finally.
Finally.
Jeez, sorry about
Samson, I'm
that.
gonna place you in the waiting room for a moment.
All right, thank you.
Oh, you're fine. Mark?
Yes,
All right. Calling case 2020-2500 Angel Bond versus Mark Bond. Today is Monday, June 10th, 2024 at 10:48 a.m.
Both parties are appearing in pro per in this matter. The plaintiff has filed a motion to show cause, claiming denial of parenting time in this matter. The court does note I've reviewed the judgment of divorce. It provides that by the defendant will have the first 3 weekends in the month. That's your understanding, Ms. Bond?
Yeah, the way that we have it set up is that we have parenting time as agreed, and if we don't agree, then dad will have parenting time 3 weekends a month. Yes.
Okay. Well, the problem is that the judgment doesn't identify those 3 weekends, so I can't hold anyone in contempt when the order isn't clear and there is obviously open to confusion. So what the court's going to do is the court's going to clarify that judgment of divorce and provide that the defendant's parenting time will occur on the first weekend of the month in which all of the days fall within the particular month. So in June, the first weekend would be starting June 7th, 2024, and then for the next 2 weekends, and then the other weekends of the month would go to the plaintiff in this matter. You understand that, Ms. Bond?
Yeah, the problem that we have right now is Mark has decided that Abigail is going to have full-time parenting time with him.
Okay, well, if he's gonna do that, he's gotta file a motion. Sir, you can't have that. You gotta follow the judgment. And unless the judgment's changed, so you're gonna have to file a motion.
okay, may I speak?
Yep, go ahead.
Okay, I am not keeping my daughter from going to her mother's. My daughter is 16 years old. My daughter has on her own decided that she wants to be with me full time and visit mom on weekends because of the problems that the two of them have.
Okay,
So my daughter has chosen, other than me physically picking her up and putting her in the car and making her go, my daughter is choosing this on her own at 16 years old.
okay. Well, as a parent, you have to show guidance and you have to basically
And I
show her that she's gonna have to go with mom. And
Your Honor, this has been ongoing for 2 years. First of all, for almost 2 years, we haven't been doing the weekend thing. We've been doing a week with me, week with her for almost 2 years. So what's in the court papers hasn't even been in effect with us for almost 2 years.
that may be, sir, but the only thing sir, stop. The only thing the court can do is enforce the order, and the judgment provides for the 3 weekends. That's all I can do. I can't enforce something that the two of you have come up with and that you're doing or not doing. I can only enforce the written orders. So that's all that I can do at this particular time, unless you file. If you file a motion to change the orders, then we can address that. But that's not before the court today. And so at this point, I'm not finding you in contempt, sir, because the judgment wasn't that clear as to the parenting time. I'm attempting to clarify that, saying that the plaintiff's parenting time will be those 3 weekends, the first 3 weekends of the month. starting with the first weekend in which all of the days fall within that particular month. So that's what I can do today. If in fact there's not compliance with that, then we can look at, again, show causing once the order is clear. And sir, I will just caution you that obviously if you're not assisting in the parenting time occurring, you could be held in contempt and you could go to jail. Then the child would have to go with mom because you wouldn't be there to have custody.
All right. And
Okay?
so, I mean, and that's all well and good. What's the paper you said I have to file? Because this has been going on for 2 years. This is my daughter has been talking to me and has talked to her mother on a couple different occasions.
What you're gonna
about
have to
wanting-
do, you're gonna have to file a motion to modify custody. And effectively, what you're seeking to do is, yeah, file a motion to modify parenting time in this matter.
Okay. Okay.
So,
It's usually 18, or it can be when the child graduates high school. In some jurisdictions, some divorce decrees will stipulate it being longer, but generally 18 or 19. He just needs to file a motion. He needs to freaking get the job, get a lawyer, basically. File a motion for the judge to talk with the kid himself.
and
right.
it'd probably be a good idea for both of you. I don't know if you want to look at that now. If there is a problem between the plaintiff and the child, maybe you should seek some sort of counseling. Have you thought about that?
Yeah, that is something that I've actually, since this started in April, is something that I've wanted to do, but I've not had her with me to be able to do counseling with her.
Okay, well, the court can order that the defendant would take the child to counseling, and we could set it up with the counselor, and what would be called as reunification counseling. So, sir, do you have any opposition or objection to the counseling?
Well, I would probably recommend that we allow the family court judge to discuss some of this with my daughter,
Okay,
so that she has a voice in this at 16 years old.
I'll tell you, sir, unless she testifies, that can't happen. The court cannot
And
have
she's
communication. The only time
She's willing-
the only time a court can talk to a child is when there's a custody dispute and the court is attempting to discern the preference of the child. I can't talk to the child about disputed matters because it's not appropriate and I'm not permitted to do that.
Well, and I understand that, and I will have that motion filed today for custody modification.
Well, parenting time too.
Yeah, that's yeah, okay, that's yeah.
You can file that and we can, at that point, if you want to put in that there would be, I guess I'll ask, sir, are you agreeable to counseling so that maybe we could get the counseling started?
You know, I would have liked this 2 years ago when my daughter first started talking to her mother about this.
Well, I'm asking you now.
Because she's blaming me for not allowing her to go, and that's not the case. I'm just strictly not picking my daughter up.
I understand.
In my
Okay,
car,
we're past that.
making her go at
We're-
16
we're
years
past
old. It's
that
not
now,
going to happen.
sir. We're past that. I'm looking, are you agreeable that the child can participate in counseling, reunification counseling with the plaintiff?
If my daughter is willing to do so, yes, I am.
Okay, well, let's do that.
Because
Ms.
at
Bond,
16,
the
she
court will order that there be reunification counseling. And I'll leave that up to you, Ms. Bond, because you're the one initiating. You can get the name of the counselor that you're gonna be doing. Provide the defendant with that. You can do an order for counseling. And then what would happen, the court would order that both parties would pay one half of the cost of the counseling not covered by insurance.
Your
And,
Honor, I'm on disability and I cannot afford that.
well, then you have to, there might be somebody, like, if you go through like Summit Point or someplace like that, they would have some sort of means tested, and they would, it would be based upon your incomes, et cetera. So you can
Yeah,
do
'Cause
that.
I can't afford it. Can't even afford an attorney for this, so.
Well, do that, Ms. Bond, you can get the order, and again, try get it through a place that like that, like Summit Point, that wouldn't have, basically would charge based upon the incomes of the parties. And some case when a person can't afford it, they don't charge anything. So that might be that what happens in this case. So do that, and we can get the counseling started right away. Mr. Bond's gonna file his motion. I will tell you, Mr. Bond, that when you file the motion, file it, set it, but obviously with the order for parenting time, counseling, if you would, or reunification counseling, the court's probably not gonna do anything on that motion until we've had some sufficient time for a counselor to meet with all the parties. And I will tell you, Mr. Bond, it's to your benefit to have the child go to counseling, because if she tells the counselor she doesn't want to go, the court will take that into consideration.
Oh, and I understand that, and I've strictly have just followed my daughter's lead on this. This is
Okay, well,
The last
I will
thing
tell you, you're the parent, you're the one to lead, not let a 16-year-old lead, because we don't know what that'll lead us to. Okay?
my
So,
daughter's
Ms.
happiness is
Bond, you
number
can
one.
prepare that order, submit it for the counseling, and then he'll submit his motion, and then we'll go from there.
Okay,
Okay? Thank you both. You're free to go.
Sounds
Have a
good.
good day.
thank you.
Next. Yeah, I think his shirt said I plead the fifth, which is ironic because he didn't.
For you.
Well, you can't plead the fifth in that type of hearing.
Two people.
If you're just getting here, please go ahead and hit the like button. Judge is just
That's
looking
long.
at some paperwork. And then we'll be on to the next. He has a busy day today, folks. Remember that. Also, the judge is unique. I mean, each judge is unique in their own way. That's what unique means, dumbass. But what the fuck is this?
Probably with the deficiencies we have on these other two, we'll probably do those first, get rid of those, and then we can do McKediac.
That makes sense. Mr. McKediac, can you hear us?
Yes.
Okay, thank you. Shelley Huffman is not here yet. So
McKediac. I covered them before. This is the one with the blonde lady. She looks like an adult video star, allegedly. I remember McKediac. It was a TPO case. If you're ending a meeting and you finish it with, does anybody have any questions? And somebody raises their hand, you say, perfect, go ahead and put that in writing, send it to me in the email. I'll get it right back to you.
we will bring you back shortly, okay?
Yep.
Thank you.
Which one was that, Vicky? Right? I've been to a lot of failed meetings.
Okay, please unmute. What is your name, please? Yours? Yeah, what's the name, please?
Hello.
Yes, hello, what's your name?
Nicholas King.
Nicholas King. One moment. Sir, I'll put you back in the waiting and we'll be with you shortly, okay?
Okay.
Let's do Oswaldton first.
Yeah.
Judge, 'cause
Yeah.
makes sense, and then we go to King. Please unmute Mr. Oswaldton.
Hello,
One moment, please.
no problem.
Maybe
This
that'll
is
be
case
third down.
2024-371 PP, Gladrian Oswaldton versus Kyle Oswaldton. It's Monday, June 10th, 2024.
Osselton, this name is familiar as well, Casey. Yeah. 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 Osselton, was he getting cocked? I remember. Something's happening.
At 11:02 a.m., the petitioner is not here.
Okay. This matter is before the court on the respondent's motion to terminate. Mr. Oswaldton, as I look at the file, I note that the personal protective order was entered on February 8, 2024. You were served personally on April 2nd, 2024, and you filed your motion on May 17, 2024. Is that accurate?
No, no, Your Honor, I was never served anything. The only reason I found out about the PPO is I got a letter in the mail from the court stating that I had a PPO. I've never been served anything by Zelda or any of her representatives or any other person at that. I've never signed for anything.
Okay, hold on, let me.
The only thing that I've been served by the petitioner was the divorce paperwork that we're doing in another case.
Wait, is this the one where she was pregnant?
Okay, let me see.
Or is this the one where he has the kid and even though it's not his kid, he wants custody?
They claim that you were personally served. I'm looking at the proof of service signed by Hetty. I can't make out the last name.
It looks like Maston, M-A-S-T-E-N.
Do you know this Hetty Maston at all, sir?
No, Your Honor.
Well, there was another issue. Did you get, initially, we had that there was no proof of service served on Miss Oswaldton. Go ahead.
I sent the certified restricted mail to her on May 17th. I still have not received the certificate from the post office yet.
Okay.
I sent it to the last known address that I had for the petitioner. I'm not sure what her address is now, but I tried to do everything the right way. I worked with you guys' clerks and they helped me get all the paperwork done.
Well, I can't proceed today until we have a proof of service, okay?
Okay.
Because I can't proceed unless she's been served. So what you're gonna have to do is get that proof of service, and then what you're gonna have to do is renotice the hearing, and that way it gives her an opportunity to be present. She can have that the person that claimed to have served you with this matter, they can have that person present and they can testify too if they want to. If not, then But I can't proceed because we don't even know that she was served yet.
Okay.
So-
So how would I go about, because I have sent the paperwork to her through that, like I said, the restricted, certified. So I don't really know how all this stuff works, to be honest with you, Your Honor.
Well, you're gonna have to get back the proof of service from the post office where she signed for it. And then you'll have to do a renotice of that hearing on your motion. Unfortunately, you'll have to serve her again with that, but if she has an address, et cetera, and she was served, then you could serve with the renotice at the last known address. Okay?
Okay, yeah, that's what I did originally. It was just the last known address.
Yeah, that's fine. But do that and then we'll know that she's been served at least with the original motion.
So at this time, everything stays the same.
Everything stays the same. I can't do anything until we know if she's been served or not.
Okay, Your Honor. I will do whatever I can. So will that just be refiled through the clerk?
Yeah, yep.
Okay, so everything I already did, just resend that paperwork.
Resend it with a new notice of hearing. Get it out enough time so you can get the notice back if you do. Okay?
Okay. Yeah, they
Thank
told me
you.
it would take 15 days if she didn't sign for it, and I still haven't gotten it back, so I don't know.
I can't tell you. I don't know either.
Roger, I understand, Your Honor. No problem. I'll get this taken care of and get it filed as soon as I can.
Okay, thanks.
Thank you for your time.
Yep, you too.
All right, let's go to King, because I only have the respondent here, not the petitioner. Let's find out what's happening.
He was very polite, and he
Can you hear
has
us, Mr. King?
Hello.
here to say thank
Yes,
you.
1 moment, please.
Thank you.
My camera.
Yes, please.
You duh. Turn on your camera.
Okay, so now this is case 2024-1027 PP. Elizabeth King versus Nicholas King. It is Monday, June 10th, 2024 at 11:08 a.m. The petitioner plaintiff is not here.
Okay. Okay, Mr. King, in this matter, the court's attempting to determine whether you accomplished service of your motion to terminate on the petitioner in this case. And I can't
Can't finish a sentence? Can't what, Judge?
I can't tell. Do you have a proof of service or something showing service of your motion to terminate?
Yes.
And what date was the petitioner served?
Give me 1 second, please. This is got messed up. That's right. Remember today.
Let him know that I served it. I served it
Who the hell's that?
when I dropped off the motion at the courthouse that day. Because I don't know, it's not in here. They gave you the proof.
Oh, this one? Or not?
I can get you the print up, Judge.
Okay, if you can, I'm looking
Yes.
for it.
Just a moment.
Oh, what I have is all the stuff from the divorce stuff and it's.
What did you do to the paper?
It should have all been right here, 'cause
Okay.
sorry about this, we're going through a lot of paperwork.
Well, we do have it, but what PPO coordinator
You're
says
talking
is
to a
that we're
literal
missing the
judge.
checkbox where I circled.
I think he's doing
Other than
less
that, it looks
paperwork
good to
than
me.
you.
Mhm. It looks like it says personal service. Mr. King, just to clarify, I'm looking at the proof of service. It was filed on May 28, 2024.
Yeah.
It looks like it was served personal service on 5/24/24. Do you know if that's accurate or not? The
Yeah.
form was, it wasn't clear any of the boxes that were checked. That's why I wonder.
Okay, yeah, that's the date that it was served.
See, I mean, it looks like that they checked that.
I see that on personal service.
Yeah.
I do. I believe that's the
Okay.
X there.
Well, sir, what I'll do is, court does note that it is now 11:12 a.m. It was set for 11 o'clock. Petitioner is not here. She's not filed anything. It does appear from the proof of service that she was served. I don't know what the question was by the PPO coordinator, but as a result, the court will grant your motion to terminate the personal protective order. And do we have those forms, or does he have to submit it?
Oh, I'm sending them to you right
Okay.
now. Yeah, the order after.
Yep, the court will enter an order which will terminate that personal protective order, but just so you know, it remains in effect until such time as, we get it signed. So I'll be signing it here shortly, but
Okay.
what happens is the police agencies won't get it until we file this order. So there may be a delay of, a day or so or whatever. So just caution you shouldn't have any contact with the petitioner because that could cause you to be arrested, if nothing else.
Wait, what about being arrested?
Don't have any contact with her until till that is signed, and it might take a minute for the police officers to get the notification that it's been canceled.
Oh.
But ask him how long before you get a copy of it.
How long until I can get a copy of it?
So it's been charged.
You can get a copy of it from the PPO coordinator or from the clerk's office. You can get it today.
Okay, does that cost anything?
No. Well, to get a certified copy, it will cost you $10 and $1 a page.
Okay,
But part of our procedure is that we mail out copies to the parties. So it's gonna be a plain copy, but it'll go out in the mail probably tomorrow.
Yeah, you'll get a mailed copy, but if you want one before that, then you'll have to come down and purchase that.
Yes.
okay,
Okay?
okay, thank you.
Anything else, sir?
No,
Okay, thank you. You're free to go. Have a good day.
no, you guys too, have a blessed day.
All right, good. Now we go to Makidia. We go.
Now
Sheriff Ross
Makediak.
first.
Now the blonde lady, will she show up?
Well, I'll do them both. We'll call them both.
Yes, I'm gonna call both cases, but just because Shelley's only part of the show cause,
Oh,
not the termination. Oh, just a moment. We lost Lindsay.
Oh shit, she is here, Lindsay, Miss Makediak. Wow. Have a blessed day. That should be my catchphrase. Really? You know, if I did a
Can
show
you hear
with
us, Shelley?
Yes.
oh geez. I was like, what? That lady went downhill fast. It's different lady. No offense to anybody. But my catchphrase, if I did a show with other people, I would try and implement better than I deserve more. But it is very difficult by yourself to lob yourself a question of how are you doing today? Better than I deserve.
Sorry.
That's okay. Had a lot on the docket for 11 a.m. for PPOs. We just lost the petitioner and defendant in the other case. I'm just waiting here for her to reconnect. Okay, I think that's her.
Bless your heart. That's so cute. Better than I deserve,
Please
is it?
unmute Ms. Nikitia.
Oh, I learned it from what's his face.
Yes, can you hear me?
Yes, we can hear you
Yeah,
now. Okay.
oh God.
Thank you, everybody, for your patience.
Hold on, Jesus. It was from Judge Kim in Judge Kim's court. Judge Andy. What in the fuck? Porter. Thank you, MB. Judge Porter. And what's funny is that you got to realize like all he was waiting for is somebody to ask him that question so that he could say that. And I don't doubt that. That makes a lot of sense about it being Dave Ramsey. But I remember listening and I was like, he is just waiting. And if you want to make Judge Porter happy, you could just lob that one back to him and he would be so happy. But I witnessed multiple times when people wouldn't give it to him for whatever reason. Like they're lawyers, right? So they just like word things differently. So instead of asking him, like and it was always obvious to me. I was like, they could lob this over to him and let him say his thing, but no, they're not doing it. And it's so funny. I just loved it.
This is for two cases. 2024 113 PP, Lindsay McKediak versus John McKediak, and 2024 391 PP, John McKediak versus Lindsay McKediak. It is Monday, June 10th, 2024 at 11:16 a.m. Attorney Shelley Hoffman for the respondent, Mr. McKediak in the show cause matter.
Okay. We'll take that matter first because Ms. Huffman is here and you only, just for purpose of the record, Ms. Huffman, you do not represent the respondent in the motion to terminate. Is that accurate?
That is correct.
Okay. Okay. So Ms. McKediak, you filed the motion to show cause. You can proceed. Would you like to make an opening statement or simply proceed to your proofs?
Just proceed.
And you're going to have to speak up so we can hear you.
No, I don't need to make an opening statement.
Okay. Ms. Huffman, do you wish to make an opening statement or proceed to proofs?
I will waive opening.
Okay, thank you. Ms. McKediak, you can proceed and present any evidence that you wish. If you are going to testify, you're going to need to be sworn in. Do you wish to testify?
Yes, I don't understand the difference of.
Well, when you file a petition, all there are is allegations. That's not evidence. It's just allegations.
Okay.
If you are going to want to have that be evidence, you're going to have to testify to that. So that's what I'm asking you. Do you want to testify or you don't want to testify?
No, I guess, no.
If you don't want to testify, then the court's going to dismiss your petition because there'll be no evidence for the court to make a determination on.
Oh, okay, well, then I guess I have to be sworn in.
Speak up, please.
I said then, yes, I have to be sworn in?
Okay. Ma'am, what we'll do is we'll have you raise your right hand and we'll have you sworn in and then we'll proceed.
Okay.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay? Go ahead, Ms. McKediak, you can testify.
Okay. Well, he just calls me when he's drunk and threatens me and threatens my children. And he said that he's gonna bury me. And then he's mad about the PPO. So he that I filed in the first place. So he said he was gonna get PPO, and he's recently, which
Okay, ma'am, just to clarify, just so we know, because you made various allegations. I don't want general statements. If he contacted you, give us the date and the time when he contacted you as to each time.
Okay, March 18th, and January 20.
Okay, are we talking 2024?
2024, February 7th, February 11th.
Okay, let's take them one at a time, so then we can get the evidence. So you mentioned the 3/18/2024 first. Let us know what happened on that date.
He called me and told me to go kill myself.
Okay, anything else on that date?
He called me a clown due to the fact that he thought that the PPOs have gotten dropped from the last court date. He called me off of somebody else's phone, so I answered off of.
Okay, again, what date did he call and what did he say?
That was the date in which I'm telling you that he called me a clown and to kill myself.
On the 18th, on March 18th, 2024. Okay.
Yeah.
Anything else that happened on that date?
No.
Okay, what's the next date that we're talking about?
We've go backwards to February.
February what?
February 7th,
Is that 2024?
2024.
Okay. What happened?
He called me and he said that, he was going to take everything in divorce. I was going to have to live in a box. He says that he'll pour acid all over me, so that way I'll never look good for another man and no one will ever want me. And that he's going to make sure me and my kids have nothing. He does this when he gets intoxicated. So it's normally when he does it. When he's not been drinking, then he's usually, well, I don't get any, we don't contact each other, but when he's not been drinking, then
Okay, all that I don't need to know. I just need to know what happened on what dates.
Okay.
What happened? What are any other dates that you have?
Yeah, it's February 11th. He was in Florida.
Again, is that 2024?
2024.
Okay. What was said?
Just the same thing, name calling me junkie loser. And
Oh, we hit that one on the head, allegedly. Didn't we?
he said that he's gonna have someone come kill me. And he's in another state, so it won't be him, and that he'll get the kids, and just a bunch of nonsense, really.
Okay. Anything else?
No.
Okay. Any other dates that the court has to be concerned about?
Well, I hate having to do this. The other day he called my mother saying that he was going to.
Okay, ma'am, I'm not concerned about him talking to any other third parties. The PPO only keeps him from contacting you. So
Right.
he
But
can
it
talk
was
to-
correct.
Hold on, ma'am, don't interrupt me. I'm trying to explain this to you.
Okay.
He can only prohibited from speaking to you. He can speak to any other third party in the world that he wants to. So I'm only interested about when he's contacted you.
Okay. Guess the only reason I brought it up because it was a threat.
Okay, you've addressed the March 18th, 2024, February 7th, 2024, and I think February 11th, 2024. Is that the extent of it?
I mean, yeah, there's been other dates, but yeah, that's.
Okay, because the court will make a determination based upon those dates once we're through. I want to make sure that you have covered everything that you need to.
Well, just one, that was back in January too.
Okay, what date in January?
January 27th, 2024.
27th?
Yes.
Okay, what happened?
Can you imagine being in a relationship with her? The way she speaks? It is so fucking annoying. Did someone press her clown nose? Oh, fuck. It's just annoying at this point. She's allegedly very high. Like, you're talking to a fucking judge. I totally speak Valley Girl, but it's a different ballgame, like high on smack Valley Girl. It's like a lot slower and lower. A little bit drifty and shifty. Hard for me to go so slow. I honestly can't do it anymore.
Him and his girlfriend called me and told me to get my ducks in a row.
Hold on, you said his girlfriend called you or he called you?
Him and his girlfriend.
Excuse me?
Him and his girlfriend.
Okay, go ahead.
And told me to get my ducks in a row because it was after I filed and he had been served with the PPO, and he was angry about it. So they were threatening me that he was going to file a PPO back. And
Okay, when you say them, I'm not concerned about what the girlfriend said. I'm only concerned about what he said, because as I told you just a moment ago, I'm only concerned about any communication he has with you.
I'm telling you what he said.
Excuse me?
I'm telling you what he said.
No, you said they said, and I said, I don't care what the girlfriend said. I'm only concerned about what he said.
Okay, well, I guess I meant when he said them, like that they were going to, this is what he said,
Okay, go ahead.
that they were going to, like, that's what I mean by that they were going to file for PPO and that they were going to file for divorce and that they were going to get the kids. And so the PPO then which I was served is in his girlfriend's handwriting. And so was the divorce then which that he had filed was in his girlfriend's handwriting.
Okay, anything else?
No.
That's all the testimony that you have to give. Is that correct, Ms. McKediak?
Yeah.
Okay. Ms. Huffman, any cross-examination?
Yes, so, you indicated that on February 11th, he contacted you and was in Florida. How do you know where he was at?
Because it was a FaceTime call.
It was a FaceTime call,
Yes.
and so you could see Florida in the background?
I could see he told me it was in Florida.
Okay, ma'am, keep your voice up because it's hard to hear you. And I'm only saying that because you can answer and say what you want, but if I can't hear it, I can't consider it, okay?
And you said that was the date that he made a threat to you that he was going to kill you, but it wouldn't be him, it would be someone else. Is that right?
Yes.
Do you have, oh, scratch that. What time did he call you that day?
And I was in the afternoon. My phone broke, so I wasn't able to get like I don't have like a screenshot or nothing because my iPhone broke.
Okay, so I don't have Facebook or I don't FaceTime or anything like that. So you'll have to explain to me, why is that information not available just on Facebook and only on your phone?
I guess I don't understand the question that you're asking, but I no longer have a phone
But-
or that.
Okay,
So
what I'm asking is that isn't Facebook like a cloud-based messaging service or app service or something like that? Facebook, it's out in the cloud, right?
yeah, but if it can be, but if I can't log into it anymore because the phone broke, then and I had deleted Facebook. So after everything,
Okay, so you could access it from a computer, but you just deleted it, right?
no, because it sends a link to the cell phone. It'll send like a code to the phone. If the phone that is on doesn't work no more and everything, I couldn't access it. No.
Okay, on March 18th, what time did he call you?
He called me at night.
Like,
so that was probably like 2, 3 in the morning. Because he calls me when he's drunk.
and February 7th, what time did he call you?
That was at 2. I remember that one specifically being 2:22 in the afternoon because I was taking my friend to work. So I do remember that specifically being 2:22 in the afternoon.
And you were taking your friend to work, you were driving?
Yep.
in FaceTiming him at the same time?
That wasn't a FaceTime call, and I can answer with my steering wheel. And it was called over a private number, so I just answered the phone.
Okay, which date did you say was at 2:22 in the afternoon?
February 7th. When he said he was going to put acid all over me, and I never looked good for another man ever again. And he was mad because I was giving my friend a ride to work, and then he was going to divorce me and take everything from me. And
On January 27th, you indicated that they were going to file a divorce and they were going to do specific things. Who contacted you? Was it Mr. McKediak or his girlfriend?
it was both of them. I mean, it was out for his phone, but it was both of them.
It was what?
Both of them.
But what did you say before that? It was off of what?
His phone?
It was from his phone?
I believe so.
Okay, and were all of these calls off of his phone?
Not all of them, no.
Were most of them from his phone?
One of them I know for sure was off his phone. But that one, I believe, was off of his phone.
I can't hear you, ma'am.
That one, I believe, was off of his phone.
Okay, January 27th was off of his phone.
Yes.
Is there any other ones that was off of his phone?
I don't know if they're off his phone or not because they were private calls, or sometimes they were. It doesn't mean it wasn't off of his phone. It could, like, if it was private phone calls or off of somebody else's Facebook.
There's a callback to the case we did last week of the church that giving out magic mushrooms as their sacred sacrament. The psychedelic lawyer case in Texas. That was fucking hilarious. Ah.
I mean, that wasn't off of his phone.
You indicated that on March 18th, I believe you said that he called you from a different, one of these dates he called you from a different number. Do you have that phone number?
No. I don't have the phone no more.
Okay.
My phone broke. I had to get a new phone. I don't have the phone no more.
Okay, so when did you write this this
Right
motion?
Sorry.
When did you write this motion with all of these dates on it as to what was said?
I wrote it back in March.
And how did you remember what was said on January 27th or specifically January 29th or any specific date?
Because I wrote it down.
Yeah.
My phone broke after I filled like this out, but I wasn't expecting my phone to break.
I'm sorry, I didn't understand any of that.
I wrote things down, but I didn't like expect my phone to break. Where I had things saved and it didn't iCloud like storage, and so. But I can tell you whose phone I know whose phone he called me off of. I don't know the number, but I know whose phone it was. Like a lot of times, like, you know, do you know people's numbers? Like we store people's numbers on our phone. I don't know nobody's number, but if it comes up somebody's name in my phone, okay, I know their name.
Okay, that's all. Thank you. I have no further questions.
Ms. McKediak, I note when you were giving cross examination that you said you believe that the calls were from his phone. And what leads you to believe that they were from his phone?
Well,
And speak up, please.
so because it was him.
What was that? I couldn't hear you.
Because it was him, he called me off of his phone. I would believe it would be his phone.
Okay, well, that doesn't help me. I just want to know how you're saying he called you and you believe it was his phone. And you said you believe it was his phone because he called you. Hold on. You said you believe it was his phone because he called you. Well, somebody could have another phone and call you. I'm just trying to figure out how you know that it was from him, other than if you're telling me it was his voice, I understand that. But I just wanted to clarify your statement that you believe that it was his phone.
Well, because he could push *67. Like, I don't, or download text apps, I guess. Like, I don't know. I would know it was him. So, but the one phone call I know was off of his phone. It was his phone number. It came up off of his number. And then another, so I don't know.
Okay.
I just know that I get phone calls from him that are not very nice.
Other than your testimony, ma'am, do you have any documentation or other evidence of the phone calls as far as anything, messages on your phone, any confirmation from your phone bills as the calls from him, anything like that?
I had emailed the courts some videos that were sent to me, but yes, you didn't get those.
Okay, I didn't hear most of that, so ma'am, what happens, you're not coming through very loudly, so we're having to strain to hear what you're saying. All I'm saying is project. If you have to shout, do it so that we can hear.
I said I had emailed the courts some videos, but I guess you didn't get those. I don't know.
We have no videos, ma'am.
Yeah, I had sent in what evidence I had to the email that said to send it in. So I sent in that evidence.
Anything else, ma'am, that you have? Again, anything from your phone bill showing calls from the respondent or anything of that nature?
No, I don't. You can't get things off of Facebook and stuff like that. So no.
You can absolutely get things
I
like
do
that.
have one additional question from.
Okay, go ahead.
Thank you. Ma'am, what's your phone number?
26.
Or you would have had in February and March?
Well, I have a couple different numbers. I can't tell you, but I've got a few different cell phones for my kids too.
Okay, so which phone was he calling allegedly?
It's called my son's phone and my phone.
What's your son's phone number?
I don't know it offhand. Like I said, I got them stored in my phone, so I don't know them offhand. I have to look at my phone. Like I store the numbers in my phone.
Sorry, lady. My daughter's phone number is in my brain. Actually, many phone numbers are in my brain. Many. Pretty much every phone number I've ever memorized is still in my brain, memorized. I find it very odd not that I ever dialed my daughter's phone number. I just like instinctually, like when she got it, I was like, you must remember this phone number. This is a must know. This one you got to know, you know? Even though it's a new one, I have to. Because the whole point is the same. Like, what if your phone breaks? Like, what if the phone's dead and you got to call the kid? But again, oh, actually, that reminds me really quickly of a funny email that I got today, which was fucking hilarious. So it reads in part, because I won't dox the school specific. Anyways, I'm writing to inform you of an incident that occurred today. A small number of students were assaulted with pepper spray by an individual at approximately 1 p.m. while a class was off campus and within the community. This email I received randomly from my daughter's school. It said, amongst other things, student safety is our highest priority. The police are aware and investigating the situation. So I messaged my daughter and I'm like, oh, but this better not be the email that I got if she was involved, right? And I wrote, I just got an email about a pepper spray incident at school. Are you okay? And she said, yes, I'm fine. I said, you weren't involved. She said, no. And I said, phew. We live in a nice neighborhood. I mean, it's downtown. It's the inner city school, but it is interesting to me. Anyways, my daughter's fine, obviously, but I was laughing because I was like, this email went out to all the parents of the school. I hope that if the kid was actually involved, it would be a better email because it was not very comforting. Anyways. Okay, let's continue on with this shite case.
Has the names and I don't know the numbers. I know my phone number and pretty much 911, but I don't know numbers like that, cell phone numbers.
So you haven't replaced your phone yet?
Yes, I just replaced it the other day. I had to go to Best Buy, but it took a couple weeks because I had to have an appointment. So it was broke.
Okay, so were your contacts transferred?
Yep, my contacts were transferred.
Okay, so since your contacts have been transferred, can you tell me what your son's phone number is?
Hi, Arctic Wolf. I don't know what you've gotten yourself into. I'm gonna have to mute her again.
Six 03 420
5?
Yep.
How many fucking numbers are in this phone number?
Okay, I have no further questions. Thank you.
Okay. Ms. McKediak, just to clarify, is there any other evidence, any other testimony that you have to present?
I think he made that also a statement when we did the first court date saying how, I don't know, I think, but that after the PPO was filed, he had said something about how that phone call back in January was made, and because that he tried to use that as him filing for his PPO, that phone call. So I don't know. I guess that's all I want to say.
Okay, thank you. Ms. Huffman, any evidence that you have to present, testimony otherwise?
I would just call Mr. McKediak.
Okay, Mr. McKediak, we'll have you raise your right hand, be sworn in, then we'll proceed.
Sir, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes, sir.
Go ahead.
Thank you, Mr. McKediak. Did you make any phone calls to
No.
Lindsay McKediak in?
No, you have all my documentation, my PDFs from Verizon.
Hang on. Let me ask you the questions.
Okay.
Did you make any phone calls to Miss McKediak on January 27th?
No,
Did you make any phone calls to Miss McKediak on February 7th
no,
and February 11th
oh,
or March 18th?
no,
Did you make calls to her from any phone other than yours?
no. I
Did
didn't
you
make calls to her from my phone or
Okay.
any other.
And were you in contact with her via Facebook?
No. She has blocked off all my social media.
You have her blocked?
Yes,
And how long have you had her blocked?
probably since at least before December of last year of 2023.
Were you in Florida on February 11th?
No,
And where were you on January 27th?
Michigan, home. Or I might have been on the 27th. I might have actually been on the road going to Florida because I want to say I turned in the rental receipts to you, and I think I was back by the 5th or 6th. I'd have to go through my pictures.
Okay, could I share screen, Your Honor?
Yes, go ahead.
Thank you. Bear with me. It's the first.
Oh, over under on whether or not this is going to get me in trouble. I hope not the under, but let's see. What's she gonna show? I did not look at this first. All right.
First time I've ever done this. Not sure exactly what I'm looking for. Oh, this. Do you recognize this picture?
Yes.
And what is this picture?
I think it looks like of one of the bridges in Florida, and that would have been, I don't know. They're time stamped, so there's dates and times on the top of them.
So if this one says February 2nd at 11:06 a.m., would that be correct?
Yes, February 2nd. That would be on my way home.
Okay. And then this one is January 28th at 4:15 p.m.
Okay, that'd have been on my way there because I was only down there for like 3 or 4 days, maybe 5 days tops.
Okay. And so if you went down there on January 28th, if you were in Florida on January 28th, would you have left to go there on the 28th, or would you have left the day before and spent the night?
Would have left the day before because we were driving. What's
Okay.
Florida?
12-hour one way or more.
So you left on January 27th?
Yeah, and I had to. Because we left, yeah. I'm pretty sure that was.
And then,
All right, those were way less serious than I thought. I was worried what she was gonna show. Woo! Oh, it's a little bit thrilling though, you know. Mm.
I don't know how to find my desktop. I'm sorry.
Hit the Windows button and then the D, and that'll bring you to your desktop bit. It will also close all your other windows though, so you gotta be careful. But if you press it again, they'll just pop right back up. You can try that at home right now, ladies and gentlemen. The Windows button plus D.
I guess I don't know how to find my desktop. And I don't know what's loading, so hang on one second. Okay, so if I had phone records here, would any of these phone records show that you had?
Yeah, where was he driving from that would be 12 hours? I was trying to think. I was like, shit, y'all, because it takes a lot. I think that would be like a lot of time. I don't know what Windows M does, but I bet it's something different, Mac. I know, and also the little spot on the bottom makes things go away, but when you move your mouse off of that, Paul, doesn't it oh, anyways, whatever. I don't need to do it. I already have a fucking thing.
Have made any calls on January 27th from your phone to any of Miss McKediak's lines that she stated today?
Yes, the phone records are from Verizon Mobile. They're the PDF of the bill of every month. They show what time, where I'm at, where I'm calling to, and what number.
Right. I'm asking you, would any of them show that
No,
you called her at any of those 3 numbers that she gave us?
no, that's why I had them all printed off and turned into you.
Okay. And I do have them all saved on my desktop. I'm just not sure how to load them.
Okay.
But I will figure it out if I need to. March 18th, did you give me records that show all of your phone calls on March 18th?
I'm pretty sure every month that was listed from the first court hearing was turned into you.
Okay. And if I were to look through these and not find any of these phone numbers that were given to me, would that surprise you?
No.
In fact, none of these phone numbers are going to be listed on here, are they?
No.
Okay. And so that was March 18th, February 7th. If it states that you started making calls at 4:04 p.m. and you ended making calls at 7:16 p.m., would that be accurate?
No.
If that's what it says on here, would it be accurate?
What? Oh, yeah, on the PDFs? Yeah,
Yes,
that the PDFs are from the Verizon company. You can't alter them, you can't change them. That's
Okay.
your printouts, pay your bill. Those are exact usages of my phone. Where I was, where I'm at, and who I'm calling, and what times, and how long the calls were.
Okay, so listen to my question. On February 7th, if it indicates that at 4:04 p.m. you started making calls and you stopped making calls at 7:16 p.m., would that be accurate?
Yes.
Okay, and that none of those calls on here would have been from or to any of these 3 phone numbers.
Correct.
Okay. And the same with February 11th. Nothing on February 11th is going to show that you made any calls to Miss McKediak, is it?
Nope.
Miss McKediak indicated that you contacted her on February 11th and that you FaceTimed her on February 11th and you were in Florida. Is that true?
No.
And by that date, you had already rented a vehicle in Michigan, is that correct?
Yes.
And if it says that you rented a vehicle on 2/5/2024 and you returned your vehicle at 2/24/2024 from Kalamazoo dash Battle Creek International, it looks like AP. Would that be correct?
Correct.
So if you were in Michigan renting a car, you would not have been in Florida. Isn't that correct?
That's correct.
Have you ever, either on your phone or anyone else's phone, indicated to Miss McKediak that you wanted to kill her or have someone else kill her?
Absolutely not.
And did you ever state that you would pour acid all over her so that no one else would ever want her?
No.
Do you have any reason to have contact with Miss McKediak?
Absolutely not. We're going through a divorce and I have a PPO on her and she has one on me.
Is there anything else you would like the court to know?
I mean, I apologize for their time being wasted today with these proceedings. You can read through the statements, see all the inconsistencies and everything. And we'll have to be doing it again because she's been contacting me violating her PPO.
Anything else, Ms. Huffman?
No, I would like to just make an offer of proof that I do have these.
Well, I'm not gonna take an offer of proof. What I'm gonna do is, if we're gonna have to do that and you can't submit them through the Zoom, which I guess, Ms. Huffman, I only admonish you in this matter. If you're gonna submit something like that, you need to prepare to be able to do that. And the court's always available if somebody wants to call and check to see that the equipment works and their equipment works, et cetera. And so I'm not going to take an offer of proof when you aren't able to submit those, and you could have done that. Anything else, Ms. Huffman?
No, I have nothing further. Thank you.
Ms. McKediak, you have a right to cross-examine Mr. McKediak if you wish to do so. Do you have any cross-examination?
I just want to say you can rent a vehicle in Michigan and then go to Florida, and that is what he did. I mean, there was a
Ma'am, is this a question?
I guess is there does she have the receipts of when he rented the vehicle and where he returned it at? Is that
I have no idea.
Is that because he definitely called me and from Florida and stated that he was in Florida?
Okay,
So,
that's not a question, ma'am. If you have a question for Mr. McKediak, you can ask.
What the fuck? I was like, oh, we're creed framing. We are creed framing. That is a weird background. That's a weird desktop background. He schooled her and she turned so red and she's like, I am gonna just figure this out. Oh, fucking shit. Is that like a dragonfly? It's a dragon. It's a dragon.
Your questions now.
What,
Oh,
I don't have any questions for him. I
Okay.
mean,
That's what I was asking. Okay. Well, what I'm gonna do in this matter, and I'm not gonna
Your Honor.
penalize Mr. McKediac, because, go ahead.
I was able to pull up the Hertz. I have those up right now, the rental receipts. They
Okay.
indicate that he
Okay.
rented the, sorry.
Okay, what I'm gonna do, because you can't get the other, and I think it is germane and important, and I don't want to penalize Mr. McKediac because because Miss Huffman is not computer literate in this matter. So what I'm going to do is we're going to adjourn this matter to next Monday at 11 o'clock. I will have Miss Huffman make paper copies and submit all those proposed exhibits to the court in paper and send copies to Miss McKediac as well.
Miss McKediac, would it be okay if I email those to you, or would you rather them be in mail?
yeah, that's fine. But I mean, I know what happened, so I don't need them.
Well, ma'am, they're gonna be, she's gonna, I presume, offer those as exhibits. You should have the exhibits. So if she's offering to send those, you can decline that, but it's up to you.
Yeah, I mean, why would I need them? I know he called
Ma'am,
me.
ma'am, do you want them or not?
No.
Okay, thank you. Ms. Huffman, get those to the court though, so that we have those.
I will do that, and I do apologize. I'm sorry.
Okay, we will adjourn until next week at 11 o'clock a.m.
Thank you.
Stunned silence. That I understand that not everybody's a computer genius. This is very basic skills, Paul. These are very basic skills. If you're telling me that the average law school at this day and age doesn't have a fucking Zoom court course, that's a failure and a tragic oversight. Tragic oversight. I'm just embarrassed for that whole situation. There's just so much wrong here. He probably would have done better pro se because we would understand it from a pro se litigant, not from a lawyer who he paid. He paid her to be ready. And that's why it's frustrating to the judge, because he knows that. It's one thing entirely. It's literally either I've seen it handled in 3 different ways. The lawyer objects and says, I can't do Zoom. I have to do paper. I have to do in person. And they just own that from the get-go. They have the second option is they have an assistant, generally a young woman who is more than proficient at the technology, who is in the room doing most of the work for them while they sit and talk. And then the third option would be, wait, that was the first, the second. I think just I can't remember the third. Anyways, that's how we do. But most of the time it's just like a clerk or like an assistant in the office that knows how to do it, that's doing all this stuff. Or like you just sort of figure it out. Like it's really not that difficult. Anyways, guys, we had a wonderful evening tonight. It's been almost 2 hours. How quickly the time goes by. We have a video that was posted earlier tonight. If you haven't checked it out already, go do that. It's a little TPO. And tomorrow keep an eye out because there will be a video and a live for Tuesday night. It's Taco Tuesday. Get your taco stuff ready. I know I will get my taco ready. I hope you guys have a wonderful evening. Please remember that I love you. I am proud of you. And I will see you in the next video. Bye.